back with another live edition of Everything Compliance. Somewhat somber and bittersweet note, we are dedicating this episode to the memory of Jonathan's father, Eugene Marks, who left us a little over a week ago. So, with that note, Matt, what is on your mind this week?
Well, yes. Good morning, Tom, and everybody who's joining us today. I wanted to talk about corporate ethics. As much as we can all talk about good compliance challenges and enforcement actions, my eye was caught by a speech given by Michael Shu, who is the head of the Office of the Comptroller of the Currency. So that's the regulator that oversees retail banks in the United States. And Mr. Shu was speaking at a bankers convention at the end of March, where he gave this really interesting and I think overlooked speech about the importance of fairness in an organization and how a keen sense of fairness, very much in the ethical sense, will help banks anticipate compliance problems and improve their compliance management efforts. And I think that this is worth discussing, even for those of us who are not in banking, because if you just kind of swap out the word fairness and insert ethical culture or sense of ethics, his speech and his points read very much in sync with what I think every compliance professional would go through at any industry. And it's worth a close look. So, he was basically talking about how if you have a strong sense of fairness, then you will do better at managing the adoption of new technologies or new products or new services, because those more ethically aware institutions, they're going to be better at anticipating what potential trouble might look like. And so when they are innovating their systems and their products, they will innovate around and anticipate what these issues are likely to be. And if they have a good sense of fairness and ethics, they're probably going to do that well. And when compliance management and regulation finally does catch up with whatever they're innovating, then they're going to be better at coping with those new regulations. I wanted to maybe read off a short passage from his speech. It's only a couple of sentences, won't take long. But here's what he said. The traditional zero-sum game approach is to trade off compliance with innovation and growth, meaning more of one must mean less of the other and vice versa. This is short-sighted. Strong and effective compliance risk management should lead to greater freedom and more certainty to innovate and grow. A well-developed sense of fairness can help ensure that compliance risk management practices are effective, especially in areas that are evolving. And that's what Mr. Shu said. I think that it's that very last part in his speech, when areas are evolving. That's the key, because a lot of times you don't necessarily know as a company, what are these rules and regulations going to be for whatever we are innovating, whatever area is evolving. And you can't really have a good compliance program at that point because there isn't anything to comply with. And his contention, and I agree with this, is that if you have a strong sense of ethics, that's going to lead you to make decisions about how you innovate, how you roll out your products that are likely to be in alignment with those compliance rules once they do finally arrive and catch up. And then you'll have an easier time acclimating to the rules and regs because you're already in the ballpark of what they want and expect. So that's a lot of theory. Mr. Shu did give what I thought was a very nice pedestrian example. It's from the banking world, but he wanted to talk about overdraft fees. So if you go back to the 1990s, overdraft fees were used sparingly by banks, but then they used them more and more. So by the late 2010s, overdraft fees were a huge revenue stream for a lot of big banks, billions and billions of dollars. But most of the time, overdraft fees fall on the backs of low-income customers because they are more likely to bounce checks because they don't have much money. And is that really fair? Well, it doesn't sit well with me, at least. I get that it might be legal to impose overdraft fees, but that still leaves me with a bad taste in my mouth that I am not a low-income person, thankfully, and I don't generally have overdraft fees. But why would the poor be saddled with this more than more well-off people? It's generally not their fault that they're poor and they're struggling. So that was his point. And he said, What may seem manageable at first from a compliance risk perspective can become much more complicated over time. A well-developed internal sense of fairness can help a bank navigate these waters. And let's be honest, a lot of banks have not done that very well. That's why we have this issue with overdraft fees. And now regulators are moving to try and cap overdraft fees. And perhaps if banks had been more thoughtful about that many years ago and at an ongoing basis about what's right or wrong, do we really need to have $40 overdraft fees for somebody who bounces a check by $2? And their bank account balances are only $280 or something like that. Is that really fair? If they'd handled those kind of questions more ethically from the start, not just what's legal, but what is fair, maybe we would not be in the position of these draconian solutions of capping overdraft fees. And that is a very good principle for other companies to keep in mind. My last point would be that I think the rest of us would want to take Mr. Shu's perspective around innovation. I think it's going to be really good for artificial intelligence because we all know AI should be regulated somehow and it will be regulated eventually. But right now, a lot of AI regulation is unclear and we don't quite know how should we be rolling out AI products. In some circumstances, the sky's the limit because there's no law, there's no regulation. Not yet. It's going to come, but right now it isn't, so we can do what we want. And that's the mistake. If you have a better sense of what is fair and ethical as we roll out AI, and is your sense of fairness as a company in alignment with other stakeholders, investors, customers, regulators, is it in alignment with what they think is going to be fair? Then you will be in a better position when we eventually do regulate AI, which isn't even that eventual anymore. I think it's coming quite quick. But I just wanted to take some time and call out Mr. Shu there, that I thought he gave an excellent speech and was really getting at some deep issues about the importance of corporate ethics. And even though it's for banking, when you get into what he said and pay attention to it, there's a lot of resonance with a whole lot of other industries.
Karen, do you have a question or comment or even a thought for Matt?
Yeah, I do. I mean, I love that, and kudos to Mr. Shu, and just what you said about banking fees really resonated for me, in that corporations sometimes need to think of what can be unintentional impact on disadvantaged communities. We had that CVS facial recognition decision where they put up the cameras in low-income neighborhoods, and I understand it was a theft prevention measure, but it really impacted the personal dignity and the privacy of a lot of people in those neighborhoods. The banking fees, if you've got big minimum balances, et cetera, those fees get waived. If you have a airline credit card or gold status, you don't pay for your luggage to check in. So there are all sorts of decisions that corporations take that may make sense financially, but the impact that they have on disadvantaged populations can be enormous. And let's at least give enough credit to say maybe unintentionally so, but could be more consciously considered. So yeah, it was a kind of an eye-opening set of comments there, Matt.
It's funny, Karen, that you mentioned the facial recognition, because if I had had more time as I was typing up our remarks, I thought about the facial recognition at Rite Aid as a good example of that was legal. And I personally am not even sure I'm opposed to it because you do need some way to catch shoplifters, but the execution of it seems quite sloppy and unfair to certain populations. And we shouldn't be surprised that the Federal Trade Commission stepped in and told Rite Aid, you can't do that anymore. And they had discontinued it. I will give Rite Aid their credit that when this didn't work, they ended it. But there's a lot of things like that AI in particular is going to create the opportunity for a lot of missteps if we're not careful.
Matt, do you think, well, first of all, we often hear the phrase, I know we can do it, but should we do it? It seems to me these remarks even go a step beyond that. Would that be fair?
I mean, I think so. That he really is calling for companies to make a value judgment. And a lot of companies don't like to talk about the value judgments they make or that they do or don't make, or how their value judgments might not align with other groups and stakeholders out there whose value judgments might be different. And it comes down to ethical priorities. I do think that you are spot on. This chronic problem that companies have where we say, well, it may or may not be ethical, but it is legal. So let's do it. First off, I just categorically deny that statement, because anybody who says it may not be ethical, but it's still legal, there will be an equal and opposite number of lawyers who crop up and say, no, no, it is both unethical and illegal. And now the lawyers are fighting in front of each other, and somebody's going to have to pay them $600 an hour for the fees and all of that. It's frankly, I don't buy it most of the time when companies say we're doing this because it is legal, even if some others don't think it's ethical. That will often, in my opinion, get you into trouble. Somebody somewhere is more than happy to litigate your decision. Better to think long and hard about what in fact is ethical and why you came to that conclusion. And then you will stand a much better chance of coping with whatever litigation or compliance burdens might come along down the road, because you're probably anticipating what those will be if you're thinking about ethics deeply and seriously.
So with that, I don't see anyone else. Let's go to our special guest today, Karen Moore. Karen, what is on your mind?
Well, something that's not so distant from what Matt talked about. And, if we want to wait for the regulators to tell us what's ethical, instead of doing it ourselves as a corporate universe, then we're really asking for trouble. And one good example of that is arguably is the recently and nearly fully adopted corporate sustainability due diligence directive, or the CS-DDD. And I just wanted to take a page out of Matt's comments and step back a little bit and just look at the bigger picture here. Because here we have a 113-page directive with a lot of depth to it. And I've got, lots and lots of pages of notes, which I will try and boil down to some of the kind of salient points, at least the ones that struck me. But it occurred to me that, if you step back and say, as a corporation, we need to ensure that we're not harming the environment unduly, that the people we do business with are not harming the environment unduly, that we are respecting human rights, livable wages, disadvantaged communities, all these things that as a corporation, when we act, we have an effect on that kind of big pool of stakeholders, and just try and do our best. Then we're halfway there. And I felt that way when the GDPR came out as well. If you start from the perspective of, I have got John Doe's individual personal information, how am I using it? How am I letting John know how I'm using it? How am I protecting it? Where am I going with it? You already are halfway to compliance with the GDPR. Not all the way, because there's a lot of nuance there, but it really comes down to, are we consciously trying to do the right thing? And the last kind of intro comment I'll make there is, Jonathan, last time I was privileged to be on this podcast, I was talking about whistleblowers and whistleblower protection legislation, and you asked me, what can we do to make sure that, whistleblowers are in a good spot? And, I had a bit of a confused answer because there's so many moving parts to it. But again, in the really simplified manner, is if you don't want whistleblowers, don't do stupid things that mean that whistleblowers feel that need to blow the whistle. So, respect the environment, respect personal rights, respect the impact that you have on the community, act fairly, play within the rules, be smart, make money, do right by your shareholders. But, it really comes down to that. So I'm sorry, because I guess I sort of used up my rant opportunity. So let me dive into the CS-DDD, which, by the way, I was predicting the death knell of a couple of months ago, which was obviously too early, because on the 15th, the European Council actually approved a greatly revised version after some kind of sit-down protests by Germany, Italy, and France. Some interesting political maneuvering there. So it's just got one tiny little hurdle now with the European Parliament, which meets on the 24th of April. And then there's a 2-year window, not for it to go into effect so much as for the 27 EU member states to transpose this into national law. And so, for those of you who aren't working with EU law every day, just a kind of distinction between a regulation like the GDPR, which goes into effect for all the member states once adopted, versus a directive, which is basically saying, here are the minimum standards. Each one of you 27 member states now should transpose this into your own national laws, which is actually still going on with the whistleblower directive, which has been now mostly transposed, but even though it's well past the deadline, hasn't been transposed by all 27 member states. So even when adopted on the 24th, and I hope I'm on better solid ground for predictive outcomes, then the member states have 24 years still. I'm sorry, 2 years to transpose it into national law, in which case it will then start to apply, but in a really stepped in way, which I'll briefly cover in a moment. But for people who are listening, who are thinking, does this even apply to me? I'm not an EU company. I don't have even huge operations in the EU. It does have a pretty broad scope, even though the initial kind of barrier to entry, if you will, is relatively high. It also does cover companies operating outside the EU who have any kind of operations or income from the EU, provided they're relatively significant. But even if you have no office, no operations in the EU, you are very likely to be a supplier of goods or services to an EU company, which itself may be subject to the directive, in which case you really are getting a big heads up on what demands are going to be placed on you. Because unlike other national iterations of this law, for example, the law that we have currently in force in Germany, this doesn't apply just to your tier 1 suppliers. It goes down the chain and up the chain, frankly, to your suppliers plus their suppliers. And that's both upstream, who are your suppliers of spare parts, of raw materials, transportation, warehousing, and the like. But also downstream a bit too, in terms of who else is going to be in your supply chain. So you need to know these things, both if you are subject to it, and then also if you are supplying to a company which is subject to this regulation. So we have some breathing space, like we did with GDPR, but it's good to start planning where are you in scope and what parts of your activities are in scope. We can expect in late 2026, early 27, when these things enter into national law, it's going to start applying. And this was big compromises, I think, as a result of the Germany, Italy, France objections, a real change from the lower barrier initially. So it'll start applying to companies with 5,000 or more employees and 1.5 billion euros in net turnover. 2028, it goes down to 3,000 employees, 900 million. 2029, 1,000 employees and 450 million in revenue. So it's good to know if you're being caught up, or any of your key customers are caught up in that over time. The penalties are not small. It's up to 5% of your net worldwide turnover. It's going to be enforced locally with some sort of EU federal type oversight body. There is a direct right of action by people who feel that they've been directly harmed by violation of the law. So that's something to consider, whether we're going to end up with, I keep making analogies to the GDPR, and I recognize this is a very different animal, but if we're going to have a kind of new Max Schrems law student who decides they're going to make their name in these direct right of actions and start holding companies accountable, and it can be also a bar, violations can be a bar to public contract bidding, so it can be important there. They have promised more guidelines, so that's good as well. If you're outside the EU, you should designate somebody locally, so that's important as well. And I almost don't even know where to go. And Tom, I'm going to count on you to just pull the plug, because this could be, we could do part 2, part 3, part 4, part 5 of this. But there is a lot of detail in there. I'm just going to focus on the overall scope that it covers, and then a couple of open questions I have that we're all going to be asking ourselves. So this covers human rights and also environmental impact. So it's a pretty broad range. It's aligned with a lot of other legislation, including the OECD guidelines for businesses. So it kind of incorporates them almost by reference to know what does human rights and environmental impact mean. It is focused on due diligence. So it's that whole know who you're dealing with component. This is not the CSRD, which is akin to the SEC disclosure rules, which talks about, what do you need to disclose about your actions. And I saw it, by the way, yesterday, just as an aside, that the SEC has voluntarily set aside the implementation of the disclosure rules pending outcomes, I guess not unexpected, to different challenges. I think they're waiting to hear from the Court of Appeals in the Eighth Circuit. So SEC was in place and now it's temporarily not in place. But so it's not any of the disclosure. It's just like, what do you know and what are you going to do about it? You need to conduct impact assessments, both on the potential and also actual human rights and environmental issues that may occur not only in your own activities, but in your suppliers and your indirect suppliers as well. You need to then prevent, mitigate, and potentially end actual harm and potential harm. You need to track progress at least once a year. You need to publish an annual statement on your website in terms of what you're doing, where you're going. You need a complaints procedure. And this is where it starts to get into the, like, isn't this procurement? Why should compliance care? It's really starting to sound like a big compliance program, right? You need complaints, anti-retaliation. It'll cross-reference into the whistleblower laws that were recently put in place, and now they're going to amend those to specifically cover this. You need a really big policy. That policy should also take into account employee opinions. You have to have a consultation period with your employees or their representatives. So if you have, trade unions, et cetera, you need to involve them as well. That policy should, by the way, apply to temporary workers as well, which means that they probably need to be trained. So that's that whole other can of worms on how do you address temporary or shift employees. You need to incorporate it into your risk assessment. And then you have this whole huge due diligence, as I mentioned, both upside and downstream as well. So any kind of raw material parts development, manufacture, design, storage and transport. Downstream, any partners that are carrying out activities on your behalf, again, distribution, transportation, storage. So you need to take care of all that. And then that impact assessment that I mentioned, which can now go, hand in hand with your privacy impact assessment already required in a lot of cases by the GDPR, not to mention all the cybersecurity assessments you have to do. And my very first big question is, what on earth does this mean for due diligence and that whole know your third party? Those questionnaires are getting longer and longer and longer and longer. Our ability, I think, now to try and incorporate better AI to sort out by risk what questions are being asked to which third party is going to be crucial, because who's sifting through the responses? Even if your third party is willing to answer 500 questions covering the wide range of issues that we're supposed to be looking at, whether it's financial or legal or cybersecurity, who's going to sort through the answers and decide what needs follow-up? To what degree are we relying on the self-reporting and the accuracy of those reports and the like? So being able to really pinpoint, this is the supplier with these risks, I need to ask them these questions, number one, to try and simplify it. Number two is, to what extent are we going to start to see the ability to get some sort of a certification process in place, whether it's something like EcoVadis or something more akin to the ISD, to say, look, I already have this certification and therefore I don't need to answer questions. You can already rely on that, although the directive kind of takes issue with that. So I think really number one big question is, how do you even do this due diligence? Number two is, how many suppliers do you have, and are they necessary? Do you need to diversify? And it's created all sorts of problems for companies like Boeing and even like for NASA, when they have to distribute their supply chain all over the place to satisfy different political or financial demands. Can you reduce the number of suppliers and really get to know them and really develop trust and relationships with them that'll give you a little bit more breathing space. Question number 2 is, even if you trust and believe in your suppliers, what about their suppliers? Because now you're responsible for what I'm loosely calling the blueberry problem, that if you contract for muffins to be delivered to your office every day, and you love the baker and the baker is really great, well, what is the baker doing about ensuring that the blueberries that they put in your muffins have been sustainably sourced, and that the people picking the blueberries have received a fair wage? So it is, going to start to take that kind of thinking about, where are things coming from? How am I going to work with my suppliers? And there's a very interesting set of provisions about working with small, medium enterprises in the CSDDD that says that you need to be co-responsible, even to the point of potentially providing direct financing or enabling low-cost loans or whatever, so that your SME suppliers are also able to comply with this legislation. So it's a degree of accountability that I think doesn't necessarily exist by regulation, alongside a very interesting provision that says, if necessary, you can work with your competitors who may also be contracting with your indirect suppliers to kind of encourage, if not force, those indirect suppliers to comply with the law. So now we have a kind of competition tightrope to navigate there as well. I'm just going to pick a couple of other little observations and points here, because, like I said, there's a lot in these 113 pages, and I think that they really bear further conversation or further examination. And as we get more information and supporting documentation from the European Union, we'll also be able to get better guidance. But how are you going to staff this? The German law already says you should have a human rights officer in charge of implementing the current German version of this due diligence kind of regulation and activity. What kind of technology are you going to use that you're maybe not already using to try and sort through all of this? Can you reduce the number of suppliers? And then, this kind of interaction with other laws, because there are already other laws on the books with the EU. So that's kind of my really very kind of brief impressions of this law, which is due to be adopted in a couple of weeks, and it's going to slowly start to enter into force. But Matt, to your point, it's not a bad idea to already start thinking about, am I doing good things that are already kind of complying with the spirit of this law, not to mention all the surrounding laws, and then also, which will enable me, once the SEC is back online and CSRD, which is already in force, enable me to properly report and respond to issues and concerns.
Jonathan Marks, you have a question or comment for Karen?
Karen, if you can put your sort of soothsayer hat on, with all this stuff that's going on with regards to compliance and human rights and supply chain and cybersecurity and whatever, it almost appears to me that we're losing sight of what a 10K originally was designed for, sound financial statements and footnote disclosures. I agree that there needs to be compliance, and that's fundamentally, sort of should be ingrained in everybody. But I almost think at some point, maybe 5 years down the road, we're going to have audited financial statements and you're going to have a compliance statement, because I don't know how organizations, to your point, now there needs to be a human rights officer, there needs to be a cybersecurity officer, there needs to be a fraud officer, there needs to be this officer, there needs to be that officer. I think at some point we're kind of putting everything into the pot and assuming that it's all okay to kind of throw in there, and that this one regulatory body or maybe two regulatory bodies are really looking at this thing. I just don't know how organizations are going to handle this going forward. I just don't.
Yeah, Jonathan, I'm absolutely with you. And by siloing a lot of these kinds of subjects, you also create little power bases within an organization that don't necessarily coordinate with other parts of the organization, We're already seeing the rise of the data privacy officer within different countries. So it's not the strategic position, it's the individual country position saying, we have to do this, we must do that, we're not complying with this, we're in default, I have an external obligation to report the company. Are we going to now start seeing human rights officers doing the same thing without a kind of coordinated strategic ability to address, back to Matt's point, how do we just operate fairly and well and do make a best effort to operate as a company. One thing I do with my law students, we do a whole bunch of reading on the whole argument between stakeholder capitalism and shareholder capitalism, and they start out completely on the stakeholder capitalist corner, and as we start examining some of the challenges, they slowly start moving, not all the way over, but a lot more centric to say you can't make everybody happy all the time. We're still a for-profit organization. And if you're not a big organization and you're the sole chief compliance officer, who's now also the chief privacy officer and now the chief human rights officer, and trying to deal with, kind of cyber issues as well, where does that leave a corporation to do anything more than start checking boxes? I don't know.
Jonathan Marks, what do you have for us?
I think Matt had a quick question first.
Oh, I'm sorry, Matt.
Well, just a point to try and thread the needle between what you were just saying, and what Karen was saying. I take your point, Jonathan, that wasn't the 10K supposed to be about financial statements, but there is this evolving sense of what people perceive as valuable for a company. And, if a company really wanted to make a lot of money, well, that's easy. Use forced labor, cut corners, don't invest in cybersecurity, and you can make a ton of money. But nobody's ever going to say that is a valuable company, because it is not in alignment, to use Mr. Su's words. Really, it's not in alignment with what people see as valuable anymore. So I don't think the audited financials are ever going to go away. But no, I don't rule out the possibility there might be some sort of alternative report about all the other ways that you are trying to comply with what we as a society have decided is these are the values we hold dear. And if you're not in position with that, then you are going to suffer consequences in the market. I think that's where we're going. I don't know if it's 5 years or 20 years, but I think that you're not wrong to raise the point. I just am not sure that we've fully thought through all the implications of it.
Karen, I wanted to ask, is there a resource you might point listeners to that you utilized, or did you really just do independent research on your own? Is there some place we can begin to start trying to figure out what our obligations are going forward?
Yeah, I think the European Commission actually website is probably one of the best places you can go. It not only has the current text, it has a comparison to prior versions so that you can see what was politically needed to get this through, but it also starts to plug in a lot more resources. It has links to related laws. You can go down a real rabbit hole there, but you can look at the OECD requirements. You can look at some of the draft legislation coming up. And one of the mandates actually in the CS-DDD is for each nation state to put up its own informational website, so those will be available. So I say go straight to source. It's probably your best bet. I've seen not just some misinformation, but there's a lot out there if you start doing CS-DDD Google searches that's based on the prior draft of the law, and so there's some kind of misapprehension there about its scope.
All right, Mr. Marks, what's on your mind?
Well, I appreciate everybody, making this episode in memory of my father. My dad was a longtime CPA and a great professional, so a little bit behind the scenes here, so bear with me. I won't take up too much time. But when I was a kid, my dad and I used to watch Star Trek a lot, and he thought that some of the lessons learned there would apply later in life. And I don't think he was wrong. So I'm going to delve into the intriguing intersection of logic, ethics, and the challenges we face when confronted with seemingly insurmountable obstacles. And these are things that I talked about with my father all the time. At the heart of the discussion for me today is the Kobayashi Maru scenario, which I know Tom is very familiar with, and maybe others are as well, Matt. And I know that Tom had some back in 2022, I believe, some episodes on Star Trek and compliance. So if you haven't seen those, you probably should. But it's a concept that transcends its fictional origins to really offer profound insights into our professional and personal lives, especially in the realms of investigations and ethical decision making. And so I'm trying to come up with some concepts here today that bring this all together. So for those familiar with the Kobayashi Maru, it's really a training exercise uh, for Star Trek designated cadets to test their character and their decision making abilities. The scenario is technically a no win situation. So the cadets must decide whether to attempt to rescue this civilian vessel, which is the Kobayashi Maru, stranded in hostile territory, risking their ship and crew, and do nothing to ensure their crew's safety at the expense of the Kobayashi Maru, basically. So it's a test of logic, like I said, ethics and leadership under pressure. This brings us to the importance of logic, which my dad was a big fan of. Logic is really our guiding light in investigations, and like the Kobayashi Maru, it enables us to dissect complex situations, differentiate between correlation and causation, and build our conclusions on solid foundations of evidence and reasoning. And logic helps us to navigate those murky waters of uncertainty, guiding our decisions with clarity and precision. Yet, as my dad says, logic alone isn't enough. It must be complemented with ethical considerations, for what is logical is not always right, and for what is right is not always logical. Sounds like Dr. Spock, right? Ethics becomes the beacon that guides us through the moral dilemmas which we all face every single day in what we do. The ethical dilemma of the Kobayashi Maru scenario, to me, is somewhat clear. It's do we risk everything to save others, or do we prioritize our safety? In investigations, for example, we often face similar ethical quandaries. How much should we invade someone's privacy to uncover the truth? How do we balance the public's right to know against an individual's right to confidentiality? These are not questions that logic alone can answer. They just can't. They require a deep ethical reflection and an understanding of the broader impact of our actions on individuals, communities, and society at large. The Kobayashi Maru scenario, for me, and I know my father, teaches us that our character is tested in the face of unwinnable situations. And we're all faced with unwinnable situations. It's not about the outcome, but how we respond to the challenge, as my father used to say. Balance logic with ethics and make decisions that, while not always leading to success, reflect our values and principles. It reminds us that sometimes the journey is more important than the destination, and that in the real world, unlike in Star Trek, we do not have the luxury of reprogramming the simulation to ensure a win. We must make the best decisions we can with the information and tools at our disposal, always striving to act with integrity and with honor. In conclusion, I'm sure my dad would say the same thing. Let us take these lessons of the Kobayashi Maru to heart. Let us approach our investigations and ethical dilemmas and daily challenges with a blend of logic and ethics, with courage and humility. May we face our own no-win scenarios not as tests of our ability to succeed at all costs, but as opportunities to demonstrate our commitment to doing what is right, what is just, and basically what is true. Well, not basically, but definitely what is true. So, thank you for remembering my dad, Gene Marks, who's a CPA, who passed on March 30th. Sorry. He was an awesome human, father, and friend. Live long and prosper, Dad.
Karen, do you have a comment for us?
Yeah, First of all, Jonathan, my heartfelt condolences. I know you've got a lot of amazing memories of your dad that are going to help you through a very tough time. And I love all your comments about just doing the right thing. It seems to be the theme of today's podcast. So great honor to your dad too, and reflecting his values. I do have one question for you, especially with the Star Trek reference, which I love. Is sometimes we focus so much on the rules, we forget about getting to the right place the right way. And how important is it for compliance officers to really enforce the rules if the person who maybe is violating some of them is still in control? They're not doing any harm and they're getting to the destination they need to be.
I think that happens, Karen, more often than not, and I think that those types of behaviors are ones that are often tolerated and overlooked for the sake of the bottom line. And I think with regards to the level of accountability that is now being really focused on with regards to the regulators, I think if somebody found out that a history of that actually existed within an organization and the company did nothing.
We lost him.
Like we lost Mr. Marks. Well, then we'll move across the country to Jay Rosen. Jay, what's on your mind this week?
Thanks, Tom. This Everything Compliance Group gets together every 2 weeks, and it seems like each fortnight we learn about a new FCPA violation. Earlier this year, we looked at bribery schemes by SAP, by Gunvor SA, and the latest company to join the list is Trafigura, an international commodities trading company with its primary operations in Switzerland. This week, they pleaded guilty and will pay over $126 million to resolve an investigation by the U.S. Department of Justice of the FCPA, the Foreign Corrupt Practices Act. This action stems from the company's corrupt scheme to pay bribes to Brazilian government officials to secure business with the state-owned and state-controlled Petrobras. Sound familiar? Trafigura pleaded guilty to conspiracy to violate the anti-bribery provisions of the FCPA. Pursuant to the agreement, the company will pay a criminal fine of almost $81 million and forfeit $46 million in ill-gotten gains. The department will credit up to $27 million of the criminal fee against the company for amounts that the company expects to pay to resolve an investigation by law enforcement authorities in Brazil relating to conduct. For more than a decade, Trafigura bribed Brazilian officials to illegally adopt business and reap over $61 million in profits, said Deputy Assistant Attorney General Nicole Argentieri. This guilty plea underscores that when companies pay bribes and undermine the rule of law, they will face significant penalties. The department remains determined to combat foreign bribery and hold accountable those who violate the law. The Department of Justice will continue to work with the criminal division to identify and prosecute those responsible, including both individuals and corporations. According to court documents between 2003 and 2014, the company and its co-conspirators paid bribes to Petrobras in order to obtain and retain business with the company beginning in 2009. Trafigura and its co-conspirators agreed to make bribery payments of up to 20 cents per barrel of oil products bought or sold from Petrobras, and to conceal bribe payments through the use of shell companies and by funneling payments through intermediaries who use offshore bank accounts to deliver cash to Brazil. Profited approximately $61 million from this scheme. The company's corrupt practices violated the FCPA, and this resolution demonstrates that there are steep penalties for any company that continues to bribe government officials. The department reached this resolution with Trafigura based on a number of factors, including, among others, the nature and seriousness of the offense. The company received credit for its cooperation with the department's investigation and affirmed acceptance of responsibility, which included providing timely updates on facts learned during its investigations, facilitating the interviews of employees and agents, producing relevant, non-privileged documents and data to the department, and providing all relevant known facts to it, including information about individuals involved. However, and particularly during the early phase of the investigation, the company failed to preserve and produce certain documents and evidence in a timely manner, and they took positions that were inconsistent with full cooperation. Trafigura also engaged in remedial measures, which include developing and implementing enhanced risk-based policies and procedures relating to, and among others, anti-corruption, the use of intermediaries and consultants, third-party agreements, and joint ventures. Enhancing processes and controls around high-risk transactions, investment of additional resources in employees, training and compliance, and proactively discontinuing the use of third-party agents for business origination. However, the company was slow to exercise discipline in remedial measures whose conduct violated company policy. In addition, Trafigura's prior misconduct, though not recent, includes a 2006 guilty plea by the company's German subsidiary. Trafigura's 2010 conviction of violating Netherlands export and import laws in conjunction with discharge of petroleum waste in the Côte d'Ivoire. While the company ultimately accepted responsibility for its conduct, the early posture in the resolution negotiations also caused significant delays and required the department to expend substantial efforts and resources to develop additional evidence. Accordingly, the company determined that the appropriate resolution in this case was for the company to plead guilty on one count of conspiracy to violate the FCPA. The criminal fine calculated under the U.S. sentencing guidelines reflected a 10% reduction off the 5th percentile of the applicable guidelines range, which accounts for Trafigura's cooperation and remediation as well as its prior history. Well, welcome to the FCPA Club, Trafigura, and let's keep in mind that we are in the early days of an election year. So now I'm asking my fellow Everything Compliance pundits, as well as our listeners, to look into your own crystal ball, and why don't we put forth the name of who's going to be the next name and company added to our FCPA list of shame. Tom?
All right. Well, I'm going to follow Jay more directly than I typically do, because I want to talk about an aspect of this case that I know has raised some eyebrows, if not question marks, and that is the lack of a monitor in this case. And what I wanted to do for this episode is go through the 10 factors that prosecutors are to consider as laid out in the, quote, revised memorandum on selection of monitors in criminal division matters, end quote, released March 2023 over the signature of then Assistant Attorney General Kenneth Polite. And I'm just going to go through each factors and maybe see if any can give us insight as to how this company avoided a monitor. Number one, the corporation voluntarily self-discloses. Trafigura did not do so. Number two, at the time of the resolution and after a thorough risk assessment, has the company implemented an effective compliance program and sufficient internal controls to detect and prevent similar misconduct in the future? That language was not in the plea agreement or information. Number three, at the time of the resolution, the company has adequately tested its compliance program and internal controls to demonstrate they would likely detect and prevent similar misconduct in the future. Once again, no language one way or the other in the resolution documents. Number four, whether the underlying criminal conduct was long-lasting or pervasive across the business organization and was approved, facilitated, or ignored by senior management executives or directors. Well, here we had a 2003 to at least 2019 bribery scheme. The FCPA component of this focused on 2009 to, I believe, 2014, because that's when we had U.S. jurisdiction, because Trafigura was stupid enough to come to the United States to plan out the bribery scheme. But it was reported, at least in the plea agreement, that the conduct occurred both before and after. Number 5, whether the underlying criminal conduct involved the exploitation of an inadequate compliance program or system of internal controls. Well, when you have bribery for 15 or 20 years, I think that's a plus. Yes. Did the conduct actively involve participation of compliance personnel? There was no mention of that in the settlement documents. Number 7, did the company take adequate investigative or remedial measures to address the underlying criminal conduct, including termination of business relationships and practices that contributed to the conduct? Well, apparently there was nothing in the resolution documents about the investigation or the remedial measures, but we do need to note that the company stopped using third parties for originations. That was specifically cited in both the information and plea agreement. Number 8, at the time of the resolution, had the company's risk profile substantially changed? This was not reported directly in the resolution documents, although once again, they had stopped using third parties for origination. Number 9, whether the corporation faces unique risks or compliance challenges. Well, I think given the conduct of the company, that was pretty unique, but in the oil trading industry, we've heard several recent FCPA enforcement actions. So I'm not quite sure how that shakes out. And number 10, is the company subject to other oversight? This is a Swiss trading company, so there may be oversight from Switzerland. There may be ongoing oversight from Brazil. But those are the 10 factors. And of those factors, they're really the only positive one I could see, which would suggest not the need for a monitor, was the change in the business practice of using third parties for originations of new business opportunities. Nothing, obviously, they didn't self-disclose, nothing in about a thorough risk assessment, nothing in there about an effective compliance program, nothing in there about testing your compliance program. So the Department of Justice can put a monitor in or not put a monitor in, depending on the obviously facts of every case. But if they're going to change, my request would be that they communicate that to the compliance community, because it seems to me this case, at least laying out under these 10 factors, would have been one which would have qualified for a monitor. So maybe that's either an extended rant or my part for today. I know several people on this episode have had thoughts and or comments about that. So Matt, I'm going to start with you.
Well, thank you, Tom. So yeah, I have been giving this enforcement action and several others recently, I've been giving them the side eye for a long time now. That, I mean, clearly you could make an argument for a compliance monitor. Here with, I think it was Gunvor that we've just talked about, Freepoint was another one. All three of them are commodity brokers who are somehow ensnared in Latin American corruption. You could say the same for the SAP enforcement action that happened, I think it was announced in January, which did not involve Latin American Petrobras schemes, but still that was recidivist behavior at SAP as well. I would zero in on, Tom, out of all of your 10 criteria there, I think the key point is criteria number 8, which is whether the company's risk profile has changed enough to make repeat offenses really unlikely. And I get that making a substantive structural change, such as no longer using third-party intermediaries for business origination or various other tasks, but I get that that is a deep structural thing. Are we now saying that's going to be enough to satisfy this criteria? Because look, commodity brokers, SAP, lots of other big global companies, they deal with corporate, with government customers in high-risk jurisdictions all the time. They have before. They are doing it now. They will continue to do so. So are we saying that these changes are going to be enough to say that the risk profile is now changed enough, even though you're working in the same environments with the same sketchy customers, because you have torpedoed your third-party usage or taken other steps? Is that going to be enough or not? That seems to be the key thing. Tom, you did talk about, I think it was point number 9, whether or not the misconduct was unique. I mean, let's be honest, it's everybody and their uncle who has touched Petrobras in the last 20 years seems to be under FCPA investigation, so it's not unique by any stretch of the imagination. But yeah, man, I mean, we need a more fulsome explanation, I think, of why these companies are not getting monitors. Maybe there is a justification there, but a lot of people are confused about it, and that requires a more fulsome and coherent response from the Justice Department about exactly what's going on, in my humble opinion.
All right. Well, with that, we will move on to fan favorites, shout outs, and rants. We'll keep the same order. Matt, do you have a shout out and or rant for us?
I do. I am going to calm down here and give a shout out today. I just want to give a shout out to World Central Kitchen and their founder, Jose Andres, who is a wonderful human being, and all of the people at World Central Kitchen who are doing good work. And that is clearly on everybody's mind because they just had 7 of their staffers killed, and they were trying to serve food in Gaza and were killed apparently by mistake by Israeli army forces. I'm not going to get into how that actually did or did not happen over there, but keep our eye on the more important ball, which is that World Central Kitchen is trying to do good things. They work under very difficult conditions in Gaza, in Ukraine, around the world. And what Jose Andres decided to do, I think he founded it in 2014 or 2010, was an excellent thing. It is heartwarming to see so many people support World Central Kitchen, so many volunteers, so many workers. It is a shame that 7 of them lost their lives, but it is still one of the bright spots in this world, which can often look pretty dark and mottled a lot of the time.
Karen Moore.
Whew. So for me, also, if we're going to be taking high roads here, a shout out to the Austrian government and restorative justice. Austrian government amended its citizenship laws in 2019, arguably a little late, to grant citizenship for people who were victims of Nazi persecution and their descendants. And so as of a few weeks ago, I am now also an Austrian citizen, which is a real shout out to my ancestors, my mom and her parents, and the so many people that they lost, as a result of which I have a very, very small family. And I really give a lot of credit to the consulate here in Washington, D.C., Elizabeth Borges Ereth, who is one of the consular officers who made the process very respectful, but also, the authorities there are bending over backwards to try and create documentation for people who left without a whole lot. My mom's exit passport's got a big, Nazi swastika on it, but that's one of the only demonstrations I have that she was ever there. So, shout out to the Austrian government for doing the right thing, even if they're a little late to the game.
Jonathan Marks. You're on mute, Jonathan.
Is that better?
Better.
Yes.
Great. I want to give a shout out to my dad for, almost 58 great years of being with him and all that he taught me and all the lessons learned. And the fact that towards the end of his life, he got me to actually drink soda again. So, Dad, here's to you. He loved Doc Brown's, what is this stuff? Cream soda, Diet Cream Soda. So, cheers, Pop.
Jay Rosen.
I have a shout out, and it's non-sports. I'd like to remember the actor Lou Gossett Jr., who passed away on March 29th of this year. He was the first African-American actor to win an Academy Award for supporting actor in 1982, and this was from the seminal movie Officer and a Gentleman. And it's a family broadcast, so I won't use some of the back and forth between Gunnery Sergeant Foley and Zach Mayonnaise Mayo. But I have to say, I'll date myself. It was one of my first rated R movies, but I loved Lou Gossett there, and may his memory be a blessing for us all.
I'm going to shout out to Ronel Blanco. Ronel Blanco is a 30-year-old Major League Baseball pitcher for the Houston Astros, who in his 7th game of his Major League career, having premiered in the big leagues when he was 28, threw a no-hitter. It was the Astros' first win of the season. Up until that time, Blanco had 6 appearances. He had hung in the minor leagues for 10 years before he made it up to the show. So I want to shout out to him. The Houston Astros have the most no-hitters of any team since 1962. And manager Joe Espinada was his first win was a no-hitter. So Ronel Blanco, thanks for hanging in there. Thanks for throwing a no-hitter, and thanks for some great baseball. Well, ladies and gentlemen, this has been a great episode. I wanted to thank everybody again, and I can't wait to see what we can do when we get back together. Thank you, guys.
Thanks, Tom.